This is an age of disruption, of profound revolutionary change.
What we're really asking ministers is to empower the ambassadors.
The only thing that you really push forth is the truth.
You don't see many women represented when it comes to the decisions as to how to handle the pandemic.
Well, I hope everyone is sufficiently replenished with caffeine for the purpose of taking us into the second half of this afternoon's session, where we'll be talking about the Digital Markets Act as part of Politico Live's AI and Tech Summit 2022. My name is Samuel Stolton. I'm a Politico reporter covering tech and competition. I'll be moderating this session where we'll discuss the next steps in the implementation of the DMA, how the prohibitions and obligations may provide a benchmark for global jurisdictions clamping down on big tech abuses, and also what the EU needs to do in order to ensure that the DMA delivers on its original intentions. For this cause, we are very pleased to be joined by a stellar lineup, including some of those who were at the front and centre of the negotiation process. Here in the studio, we are joined by Mathieu, Head of the Digital Economy Department at the Directorate-General for Enterprise within the French Economy Ministry. And we also have Robin Schlinkert, Director for Products at DuckDuckGo, here with us. And tuning in remotely, we have MEP Andreas Schwab from the EPP Group, obviously the rapporteur on the DMA file. And we also have Jan Kramer, Professor and Chair of Internet and Telecommunications at the University of Passau, and also Academic Co-Director at the Centre on Regulation in Europe. For those of you in attendance, both in person and online, we'd love for you to get involved, so please log into the Swapcard app, for which you should have received an invitation, and send us your questions on there. And also don't forget to tweet us using the hashtag PoliticoAI. So, without further ado, I think it's just about time to jump in with our discussion this afternoon. We haven't got too much time, so let's get straight to the point. Mathieu, the DMA has been adopted now. Obviously, many of us, particularly if you're a Politico Pro subscriber, have seen the 4-column document from that final session on March 24th. And of course, many of those at the centre of the talks have highlighted the speed at which this text was adopted. Maybe you can give us an insight into your instructions, if you like, from Paris to adopt these rules as quickly as possible, and why was there such a sense of urgency?
Well, I think it's good to get back to the genesis of this text, which really stems from the conclusion that is now widely shared, that the repetition of sanctions in antitrust environment was no longer a sufficient incentive to really change the way the digital markets were functioning. Fairness was at stake, the ability for new competitors from Europe, but also from other regions of the world was being challenged. And it was an urgency, because in this digital environment, waiting for procedures that last too long, when you come to a decision, the complainants are dead. And so there was this urgency to act on fairness, to act on contestability of these markets, and that's why there was also so much pressure in building the text and coming to a conclusion. The ability to deliver this in like 15 months was, I think, a good demonstration that Europe can actually come together and achieve results of significance within a short amount of time, which is not exactly its reputation all across, but it's been possible because there was obviously determination. It was not just a matter of a French presidency or anything, but it's also building on the predecessors. I mean, the Slovenian presidency made outstanding work within the council to make us have compromise very soon. Obviously, the parliament was instrumental in the success, and credit goes to its rapporteur, Andreas Schwab. But it's, I think, the realization that we had a consensus about the need to act that created this opportunity, which is historic, because it's about building the rules for the next 15 to 20 years about how these markets function.
Okay, and of course one of the, I suppose, loopholes that could open up in adopting these rules so quickly is the fact that there may have been blind spots that might emerge further down the line. And MEP Andreas Schwab, you have been particularly keen on speaking about the importance of enforcement. And we obviously saw this letter from you and MEP Eva Kaili calling for, I think, around 200 to 220 people in the Commission involved in the enforcement of the DMA, which many people will look upon as the way we will judge its efficacy in the future. Unfortunately, you weren't able to get that. How confident are you, however, that the Commission will be best placed to enforce these prohibitions and obligations, and what sort of people should they be looking for to employ in the Commission for this cause?
Well, Samuel, first I would like to be clear. What I haven't got is so far an answer letter from the French presidency, but I have never put into the DMA any rule that we need 220 people. This is not part of the legislation which is topical. This is part of the budgetary procedure. And I've been speaking to our colleagues that are working on the budget, and they will ask for these people when the procedure starts. And it's a nice proof of the fact that when Europe is working together, you can do better and stronger together. And that is a message that we have been seeing recently very often. We see it now in defense. Finally, we have been discussing for more than 20 years. We have seen it in digital already before. But with the program of Ursula von der Leyen in the European Commission, we see it also with the Green Deal. And therefore, we have to make that a more holistic exercise. And if we put more responsibilities on the level of the European Union, in the hands of the European Commission, there has also to be more staff there. And that is urgently needed to make sure that Europe can deliver on these important policies that Mathieu has perfectly explained. And therefore, we are calling for more persons, for more digital scientists, for data analysts, for lawyers, to make sure that the DMA can become a reality and really start a new era in tech legislation. And we could also imagine that, for example, there is a shift from the national level to the European level in manpower, because some sort of specialists that were there at national level, they might be useful now at European level. And therefore, the cooperation between the European Union member states will become stronger and stronger.
Mm-hmm. Okay, and Mathieu, I just wanted to give you the opportunity to respond. Have you seen Andreas's letter there? Do you agree with the points raised?
Oh, we've been, even before the presidency, we've been part of the Friends of an Effective DMA, pushing for a strong organization being put. Obviously, the question of resources is rather a question for the Commission than the presidency, but I think Andreas pointed out a very important aspect in the cooperation that is part of the DMA between the Commission and the national authorities, where there are very significant skills at hand, and a part of the success of implementing the DMA will go through this coordination between the European and national levels.
Okay, I'm just pursuing this narrative of implementation a bit more. Robin, I mean, how important is it for you and for companies like yours, obviously DuckDuckGo, working in, some may say, one of the least competitive markets in the digital economy, search, to be able to have a seat at the table and talk to Commission enforcers about the application of the rules? How important is that for you?
Well, first of all, we're obviously trying to make the market a lot more competitive. So hopefully, in a few years' time, it won't look quite such a monoculture it is. And it's not just us; there's other players in this market as well. Secondly, we have obviously limited resources. You know, Google has, I don't know how many these days, 150,000 employees, 200,000 employees. Apple is similar. We have about 150. And most of them are engineers, they're not policy folks. So it is very important for us to be engaged in these discussions, to have a seat at the table. But at the same time, we have to make sure that it doesn't end in some sort of minutiae where armies of lawyers pore over details. It has to be simple, it has to be focused on the critical things, and has to be judged at least in part by its outcomes.
Mm-hmm. Okay, great. And I mean, before we even get to the stage talking about enforcement, we have quite a long period ahead of us to wait, actually longer than the actual process for adopting the rules. So platforms are likely to be brought into compliance in early 2024. Jan, I just wondered, why have we got this long wait? And I mean, is this provision in place basically to give the platforms the time to update and change their products and services?
Yes. So, I mean, first, let me point out that the DMA is not going to break the internet or is not going to make these big companies subject to the DMA a loss leader in the future. But nevertheless, the DMA is quite a complex and quite a big change, and therefore, you know, on the one hand we can be enthusiastic, but on the other hand, it's really something that needs a lot of time for implementation, and the devil is going to be in the details here. And for this reason, 2 years' time doesn't seem too much actually for implementing, and we'll also be seeing how willingly the big tech companies will actually be implementing these changes that are necessary. We have seen in some other countries, the Netherlands, for example, that some of the changes that were required by competition authorities were not undertaken, and there's sort of strategic non-compliance. So I'm semi-optimistic that we actually have all the changes being implemented in 2024 when they're enforced.
Mm-hmm. Okay, and I mean, Andreas, just to bring you back in now, obviously Parliament perhaps wanted a bit of a shorter time frame before platforms would have been brought into compliance with the rules before early 2024. What do you envisage will happen during this period? Are we going to see legal challenges from some of the gatekeeper platforms, both against the prohibitions and obligations, against maybe the designation procedure, against even the legal basis of the DMA? Are these types of things likely?
Well, I think first of all, we have to be very clear on this. These are the biggest companies of the world. They have excellent lawyers, and there is a lot of money behind. So in a democratic society, you can go to court for the most stupid question if you have the money to do so. And therefore, we should not stop anyone to do so. If this, however, has a negative impact of your company's appreciation, you will doubt about that. And I think the DMA has been based on a very fair and proportionate assessment of the facts, has been not too far-reaching. And therefore, if companies that might be covered by the bill will go to court, they will create quite a negative public feeling about them, because we don't want them more than just accepting the law that is already there before, has just been difficult to be applied. But that is not up to me to comment, because we are convinced that the DMA is proportionate, is excellent also to be applied by the European Commission, and therefore I would not recommend to go to court, because there will be no chance to win. If so, for sure there is a chance, but the law is the law, and the decision of the court will only come into force later, and therefore this will not stop the application of the law. The entry into force, I think, is a place where the regulatory dialogue will give a chance to companies to also to steer the process. I have just had a conference before this, where I've been asked as to whether, for example, the front principles for the app stores and how they are foreseen. Honestly, it's only a principle which is foreseen, and it can be well be that, for example, Apple and Google for the Android and for the iTunes App Store will have different approaches of how to manage this. There is no uniform pricing needed. There is no uniform regulation needed. It's a principle that companies will have to provide with basic information to the European Commission, how they apply it and what the basics behind are. And then they are quite flexible, these rules. And therefore, I think it's also a unique chance to make legislation possible in a very smart way. And therefore, I'm also a bit proud of that approach of the DMA.
Smart regulation. Thanks for your comments there, Andreas. Jan, perhaps one thing that you don't think is so smart is Parliament's amendments to include interoperability obligations for messaging services. You particularly have been critical of the horizontal interoperability rules. You wrote a paper on it recently. Tell us a bit about the issue you have here and why you think this simply won't work, and then maybe we could get Andreas to respond.
Yes, thank you. So let me be clear that I'm fond of the interoperability obligation when it comes to opening up operating systems for third parties. I'm not so fond about
we're talking about vertical
exactly. And I'm not so fond, as you say, about the messaging services. And the reason is the following. The reason is that, we have a similar obligation in telecoms. And even in telecoms, it wasn't a huge success in terms that it broke incumbency. We still have the same incumbent firms having the dominant market share. And here there is a better case. But the problem with the digital economy is that it's a very fast-paced, innovative economy. And there's going to be a lot of, so whatever interoperability we have, it's just going to be on basic features, and it's just going to be an imperfect interoperability. That means that network effects remain, the tendency to go to the larger entrant remain, and at the same time, it's putting a constraint on innovation. It's making end-to-end encryption, for example, more difficult, and so on. So, and there's actually, we actually have a theory to show that it reduces the consumer's inclination to multi-home, to actually use different services. So you might be using, different messengers at the same time, which then gives each messenger the full access to the consumer, but interoperability actually impedes that. And some consumers might just be staying with the incumbent and not installing sort of an entrant. And that's actually hurting the entrants. And it's also interesting to know that a lot of entrants in the messaging services domain, they don't want that interoperability for particularly these reasons, because they're afraid that they're actually losing customers to the bigger ones because of it.
Okay, so potentially damaging to innovation, substantiating the power of incumbents. Andreas, how do you respond to those criticisms?
Well, nothing is more complicated to foresee than the future. I think there are for sure pros of this opinion that Jan has been just pointing out, but there are also cons. And the cons are that you may see here new competitors that just enter the market because they see a chance for existing businesses, like, for example, video conferences or whatever, to be additionally supported by the specific messaging services. So we don't know what the market will bring. It's true that the general nature of interoperability has not been something that was in the DMA at the beginning. It's true that interoperability is not the basic nature of the DMA, because it's about contestability of markets, about competition policy reflected regulation in the digital single market. But in the specific area of messaging services, there has been a strong political push for interoperability to become part of that contestability reflection. And now we have charged the Commission to implement it. And as I said, it's only directed to gatekeepers. It's not a general obligation for everyone. So only if there are reasonable requests of companies to connect their services with gatekeeping messaging services, then there will be an opening of APIs. And by the way, these APIs exist already. So the question is only, will there be a relevant effect in the market? And that remains to be seen.
Mm-hmm. Okay. Turning to a couple of the questions coming through from the audience now. We have one here about search. Mathieu, perhaps you would like to respond to this. And it comes from Colin Hayhurst. And Colin asks, Recital 46 is a step forward in allowing end users to select an alternative default service. However, for search engines, the only search options on search choice lists of Safari, Edge, and Chrome are only Google, Bing, or Bing syndication partners. users are denied choice of search results from outside of Google and Microsoft. What will you change to break down this 3 US company wall to European search engine challengers?
Well, I think there is competition on this market, and there are a number of entrants, recent or actually around for a number of years, that are challenging this. And it's obviously a high cost of entry market, so it will take time, but the provision in the DMA are specifically designed to enable them to get better access to the market, more equal access, and so and then it will be up to them to challenge the incumbents, to demonstrate value by bringing maybe new services, innovative services, but they will be given the necessary access to the market, which they're missing right now, because it's only 2 or 3 players that are playing integrated vertically, and not enabling this access, especially on mobile phones, obviously, where there has been already a number of decisions from the antitrust authorities.
Okay, Robin.
If I can maybe add to that. So I think it's fair to say that almost all new entrants into the search space to some extent start with Bing and or Google results. But that doesn't mean that they're the same. They ourselves, but also everyone else who plays in this space, augments the results, adds other services on top. In particular, the quick answers, the info boxes, and that kind of thing that is becoming ever more present in search results tends to be more proprietary. And the fact that people can rely, and including some of the European search engines, of course, that they can rely on Bing or on Google for a sort of base service, is a way into this market. I think for the specific question, though, as to Safari and Chrome pre-selecting a number of external search engines that can be chosen from a drop-down menu, I think that is a perfectly fair question for the DMA as to which providers the incumbent should allow there, or how maybe they can be asked to make a more general thing where you could add any search engine into these browsers.
Okay, thanks very much for your responses there. And a reminder to keep your questions coming into us. Andreas, I wanted to come back to you for a question on some concerns that have been raised only this week, actually, by a cross-section of data protection, privacy, antitrust experts with regards to the revisions that were made to Article 5.1a on the opt-in for personal data combination. And there have been a couple of letters circulated to those involved in the DMA negotiations suggesting that the amendments could result in a loophole for gatekeepers to combine data across many of their services and businesses because of the removal of phrasing that would have led to big tech firms requiring to obtain consent for every specific processing purpose. Now, that wording seems to have been removed, and one of the concerns that the experts have raised is that this could lead to a singular, all-encompassing opt-in request. Would you like to respond to some of those concerns, and are there any technical revisions or amendments currently taking place to perhaps correct this?
You have rightly referred to the word could create. So there is a large part of uncertainty with the doubts that have been expressed. We have made a very strong legal assessment of the text already before we went to trialogue. We have done that also with the French presidency in the trialogue. And we have not wanted to change GDPR by the DMA. We wanted to strengthen the consent under GDPR in relation to combination of data for gatekeepers, and therefore in 5A of the DMA. And therefore the doubts that have been expressed, they are legitimate, but they are not founded on facts. They are founded on the belief that the DMA will supersede the GDPR, but that's not the case. because the GDPR has a standalone function. There is only one element to which we refer, and this is consent under the specific conditions in Article 4.8. And this is not replacing anything else of the GDPR and not on the GDPR logic. And therefore, all the other elements that may have been wrongly used as a reason for not asking for consent, contractual obligations or whatever, they will be applicable as before. And that means that it will be still unlawful to take consent given for granted by companies if they believe that this is part of the contractual obligation. No, the use of data and the combination has the need for consent. And this is already written in the GDPR, and we have been strengthening that in the DMA. So therefore, we firmly believe that there is no change needed.
Just to get a bit of clarity on that, Andreas, if I may, as per the final text, with this amendment having been made, gatekeeper platforms will be required to request consent for each processing purpose when combining data across their services.
Exactly.
Great. Jan, I wanted to bring you back in here to discuss maybe one of the other changes that we saw on March the 24th, or at least one of the changes that was made in technical talks and then, of course, clarified in the final political meeting. To the scope, which we now see of a market capitalization, 75 billion euros. In your opinion, obviously being the researcher that you are specialized in this field, what sort of platforms will be brought under the scope of these rules? Where will they come from? Will they be predominantly from the United States? How many? Will there be European firms? What's your take on it?
Yeah, thank you. Well, I must admit, I haven't done, the math on which firms will come under the scope here and what their current market capitalization is. Actually, a recommendation we had earlier was that these firms under the DMA should have at least 2 core platform services. That is not, to my understanding, in the final text now, because this is, as I said before, a hugely complex law, and it's probably good to start with a very few companies in the beginning. And you have been alluding to the fact as well that probably will be coming from the United States exclusively, as far as I see it. And so obviously, Apple, Google, Meta, I mean, for them, there's more or less specific language in the DMA already, although this is, the jurisdiction will still have to designate them. And Microsoft probably is also going to be within the scope. Beyond that, again, I haven't looked at the figure specifically, and I don't want to prejudge here either.
Right, but I have a sneaking suspicion that Andreas and Mathieu won't agree with you there. So Mathieu, perhaps I could bring you in here now. I heard rumours from your ministry a few months ago that you had drawn up a list of firms that could come under the scope, and we've all heard these rumours in and around the bubble. Do you have any idea about the number of firms that could come under the scope of these rules and who those firms are? I mean, you surely must have some sort of a list drawn up based on these metrics.
Well, we did our math, and we did look very thoroughly with our colleagues within the Parliament and the Commission about who would be in context, and obviously that's part of the work that we do in the legislative process, that we try to assess the impact. And having said that, it's very preliminary, because many of the information that are required to assess the designation process are not necessarily public. So yes, there will be a number of companies, especially some US companies, they know pretty well they will be in scope. Others are maybe at the boundary and may question whether they will fall within the limits or outside of the limits. And just a reminder that there's an appreciation power for the Commission to assess whether or not to appoint a gatekeeper. But I would be very surprised if there were no European companies in there. And obviously, contrary to what was said, there could also be companies from other parts of the world, even maybe not in the short term, but at least in the midterm, if you look at their growth rate. Mm-hmm. So we'll see. It's also very much relying about the global economic climate. If we have a crisis on the markets, certainly that's going to change things, and so it has to be looked at. But we expect 10 to 15 companies, and not only US.
10 to 15 companies. And Andreas, this is a subject that has followed you around really since 2014, when we saw the front page of the Financial Times and the European Parliament's competition report being received with antagonism, I suppose, from the United States government at the time. The DMA, surely, in your mind, isn't an anti-American piece of regulation, is it? I mean, how do you argue against some of those critics who claim that it is?
Well, I have just had a conference with an Irish think tank. I think the issue is so clear that the Americans, and America is a huge country, a big continent. There are so many different interests. There is not only Silicon Valley. They have the same, let's say, basis of reflection for the functioning of democratic societies and the economy as we have. Like between Germany and France, even though we may have sometimes a little bit of different approaches, in the end, the basics they are identical. We are friends, and we have the same values at our hands, and that makes us, in the end, also finding all the time common compromises that lead the way forward. And that's the same between the European Union and the United States of America. Even though over time there have been some misunderstandings, some different developments, some different perceptions, and that's normal. But what merits a comment is that if you stand for your ideas, you can also make them to be a convincing element in a discussion. And I'm very sure that the Americans will come to some sort of similar approach, because as the Professor Jan has already said before, obviously a lot of American companies are just waiting for more innovation, for more contestability of markets, because they want to be there, and they have the power financially and intellectually to be there. They just need to get rid a bit of the bottleneck elements, and therefore I'm totally convinced that we can manage this.
Okay, and perhaps some of those messages are the ones that you will raise as part of a trip to Silicon Valley that Politico Pro subscribers may know is due to happen in May. Are those the type of things that you want to raise when you visit San Francisco?
Well, we are going there to work, and when we work there, then, as we did already 3 and 5 and 7 years ago, we will mention all these elements, and we will meet people from the area. We will meet people from the civil society, from the universities, but we will meet also people from the sector. And there are those that are rather defending the current situation of dominance, and there are others that hate the dominant companies. And it's about us as policymakers to find majorities how the future should look like, on a fair and equitable basis. And I think we will shed some light also to colleagues and interested stakeholders there, that what we want to achieve is a more open business environment in digital with the DMA and the DSA.
Wonderful. Well, we are rapidly, I'm afraid we're rapidly going to be cut off in the next minute and a half, but it's been a very, very engaging session. I'm sure we could have spoken for much longer, and I do hope those of you here will stick around for a glass of something stronger a bit later on this afternoon. Thank you to those of you tuning in online as well, and don't go anywhere just yet, because we have another very interesting interview coming up for you shortly. The UK's Technology Minister, Chris Philp, will be speaking to our very own Vincent Manoncourt. Thank you very much for joining us.